Now the next speaker, who will be online, and you're very welcome, Professor Liao from Peking University, who's going to talk about delimitation methodology in the continental shelf beyond 200 miles. This is a very topical subject, very topical indeed, since it's coming up at the International Court of Justice, in a sense, in just a couple of weeks' time. So, without more ado, Professor Liao, you have the floor.
Thank you, Sir Michael. Good morning, everyone. I hope that you could hear me here. Great. Thank you, and it is my great pleasure to present and participate in the 7th International Conference on the Law of the Sea, and I'm very thankful for the hospitality and the generosity of the Korean Society of International Law, ICLS, and the Foreign Ministry of Korea for their kind invitation and for assigning me within this diverse and dynamic panel. And I do feel a great pity of not being able to make it to Seoul. And I appreciate a lot the technical support of the organizers for me to connect it and to be part of this meaningful gathering. The topic I'm going to present today is delimitation methodology for the continental shelf beyond 200 nautical miles. And I followed the panel on maritime boundary delimitation yesterday with much interest, as I think almost all the speakers addressed various aspects of the continental shelf delimitation beyond 200 nautical miles. Therefore, I'm very happy to have this opportunity to discuss this topic further by reference to the judicial and arbitral practice on delimitation methodology. And I feel, just as Sir Michael just said, that this is indeed a very topical issue now, and it might be a contested issue whether I am a person of next generation, but I do feel that the delimitation methodology and the questions of the continental shelf delimitation beyond 200 nautical miles will be an issue for next generations, as these disputes are increasingly occupying the work of the UNCLOS tribunals as well as the ICJ. The actual making of the boundaries of the delimitation beyond 200 nautical miles is a novel exercise in the jurisprudence, as the first case was the Bangladesh-Myanmar case decided by ICLS in 2012. Therefore, there has been and continues to be a debate about whether the delimitation methodology developed primarily in maritime delimitation within 200 nautical miles can be applied to the continental shelf delimitation beyond that distance. And there have been 4 decisions so far, and in these cases, there was no differentiation in delimitation methodology within and beyond 200 nautical miles. And to be specific, the methodology adopted in these cases was the 3-stage approach, which was formally formulated by the ICJ in the 2009 Black Sea case. And it consists of a step-by-step exercise of delimitation. And since the Black Sea case, this methodology has been employed in every maritime delimitation case concerning the single delimitation of the EEZ and the continental shelf. Professor Tanaka calls it an orthodox methodology of the law of maritime delimitation, and the ICJ refers to it as established methodology in the 2018 Costa Rica versus Nicaragua case. So the question I'm going to ask today is, to what extent the delimitation of the continental shelf beyond 200 nautical miles can be integrated with the maritime delimitation within that distance under the same methodology? I'm going to discuss this question by examining and, if necessary, comparing the application of this methodology by UNCLOS tribunals and the ICJ. I will begin with identification of relevant coasts and relevant area, which is the initial step before applying the 3-stage approach. According to the jurisprudence, the relevant coast and the relevant area have a twin role in the delimitation methodology. First, they contribute to determining the area of overlapping claims to maritime zones under delimitation. And second, they were measured as a final stage for the purpose of the disproportionality test. But in this initial stage, there are certain challenges in the delimitation beyond 200 nautical miles because the relevant coasts are determined by looking at the coastal projections that overlap between the parties. But as we know that the entitlement to the continental shelf beyond 200 nautical miles is established in accordance with the geomorphological or geological criteria under Article 76 of UNCLOS. So the scope of the continental shelf entitlement, as well as the area of overlap, may be subject to uncertainties before the parties receive positive recommendations from the Commission on the limits of the continental shelf, which would have methodological implications in the application of the three-stage approach. As an illustrative example, in the Ghana-Cote d'Ivoire case, Ghana had received recommendations from the CLCS, and the special chamber decided on Cote d'Ivoire's entitlement on the presumption of its identical geological structure with Ghana. The special chamber then defined the relevant, my apologies. The special chamber defined the southern limits of the relevant area by reference to the eastern part of the outer limits contained in Cote d'Ivoire's 2016 amended submission, as we can see on from the map on the right. However, when the Commission issued its recommendations to Cote d'Ivoire in 2020, it became apparent that the Commission did not fully endorse the outer limits of the continental shelf submitted by Cote d'Ivoire. The CLCS did not verify the western segments of the outer limits of the continental shelf submitted by Cote d'Ivoire. And in terms of the eastern segment, it only verified part of the outer limits contained in Cote d'Ivoire's submission. As we can see by comparing these maps, it shows that part of the area contained in Cote d'Ivoire's submission, which was included in the relevant area defined by the special chamber, was not recommended by the CLCS as to be part of Cote d'Ivoire's continental shelf beyond 200 nautical miles. So I think this example shows uncertainties in the continental shelf entitlement may undermine the factual basis upon which the delimitation was effected, and as the uncertainties may have undermined the accuracy of the exercises of identifying relevant codes and the relevant area, and as a direct effect, it may also have affected the credibility of the disproportionality test in the final stage. Now I will move on to go through the step-by-step exercise of the three-stage approach in the jurisprudence. First of all, let me provide you with a general picture of the practices so far. There are two variations in the applications of the three-stage approach. One is a single exercise of delimitation methodology, that meaning that the court or tribunal applies each step of the methodology to maritime zones within and beyond 200 nautical miles in an integrated way. And this was the practice of the Bangladesh versus India case and the Ghana-Cote d'Ivoire case. And the second is, in fact, two separate exercises. Namely, the three-stage approach was applied to delimit the boundary within 200 nautical miles first, and the boundary line was adjusted and then extended to the area beyond 200 nautical miles. And this was a practice of Bangladesh-Myanmar case and Somalia versus Kenya case. Now let's take a closer look at how each step was applied with the two variations in mind. In the first step of constructing a provisional equidistance line, the Bangladesh-Myanmar case constructed only a partial equidistance line, which did not reach beyond the 200 nautical miles. And then the tribunal proceeded with the consideration of relevant circumstances within 200 nautical miles. So in this case, there was in fact no construction of of an equidistance line beyond 200 nautical miles. In contrast, the Bangladesh versus India case constructed a complete equidistance line throughout maritime delimitation within and beyond 200 nautical miles. And this seems to be a more faithful application of the first step of the three-stage approach to the continental shelf delimitation beyond 200 nautical miles. I think this point was also made by Professor Lando yesterday, and I quite agree with him on this. In the second step of examining the relevant circumstances, the notable trend is the recognition of the continuing relevance of the coastal geography. And in the three cases, as you can see on the slide, it was the relevance of the cutoff effect of the coastal configurations. In the Bangladesh-Myanmar case, since ICLS had already adjusted the provisional line by taking into account the cutoff effect within 200 nautical miles, it merely recognized the continuing relevance of this factor and said that the adjusted line would address the cutoff effect beyond 200 nautical miles. But by doing so, it refrained from addressing specifically the arguments of Bangladesh that the cutoff effect was in fact more pronounced in the area beyond 200 nautical miles. And similarly, in the Somalia versus Kenya case, the ICJ adjusted the provisional equidistance line within 200 nautical miles based on the consideration of the concavity of the coastline in a broader geographical configuration and extended the line to the continental shelf beyond 200 nautical miles without offering any reasoning. So the court in this case also avoided to consider if the adjusted line was sufficient to address the cutoff effect beyond 200 nautical miles, because in this case, Kenya also made the argument that the cutoff effect was more severe in the area beyond 200 nautical miles. Nor did the court consider if the adjustment was necessary in balancing the maritime entitlements beyond 200 nautical miles between the two parties, because it did not respond to Somalia's argument that such cutoff effect, however severe it was, resulted solely from the agreement reached between Kenya and Tanzania. In the Bangladesh versus India case, the tribunal was more specific about the examination of the cutoff effect. What is interesting in this case is that the tribunal not only examined the cutoff effect by reference to coastal projections, but also took into account the impact of the provisional line on the overlapping entitlements to the continental shelf beyond 200 nautical miles. So it went beyond a geometrical exercise of cutoff effect, because as the tribunal saw it, the provisional line resulted in a very limited continental shelf beyond 200 nautical miles for Bangladesh. Another interesting point in the second step of examining relevant circumstances is the exclusion of the relevance of geomorphological or geological circumstances in delimitation beyond 200 nautical miles. While Bangladesh argued for a larger share of the continental shelf beyond 200 nautical miles on the basis of the most natural prolongation argument, ICLS rejected this argument by observing that such factors stopped being relevant after the tribunal had ascertained the existence of overlapping entitlements. And Bangladesh withdrew its argument from the Bangladesh versus India case, and no state made similar arguments in subsequent proceedings. I think disregarding the relevance of geomorphological or geological factors is crucial for the integration of maritime delimitation within and beyond 200 nautical miles. In fact, I think it would be difficult to successfully invoke such factors in judicial or arbitral proceedings, regardless of the coasts being adjacent or opposite, because there are no legal basis for relative strength of measuring the different continental shelf entitlements, and there are no legal criteria that measures the degrees of naturalness of a certain geomorphological or geological factor, because there was no case that have ever upheld the relevance of such a factor in the delimitation previously. And besides, there would be considerable practical difficulties for the courts or tribunals to assess geophysical data, and experience has shown that judges or arbitrators are not tempted to venture into such an exercise. That said, coastal states may take into account geomorphological or geological factors as long as they can reach agreement in their maritime boundary making, and the states have done so in their practice. The matter, I think, is simply that such an argument based on relative strengths of continental shelf entitlement cannot find a place in the law of maritime delimitation as developed in the case law. And finally, and briefly on the disproportionality test, because this test largely relies on the identification and calculation of the relevant coast and the relevant area. The practice so far has been quite diverse, as I gathered on this slide. And I think it must be emphasized that the legal nature or the scientific nature of the disproportionality test has been questioned by a number of scholars, and the inclusion of the continental shelf beyond 200 nautical miles into the relevant area further adds another layer of complexity in the already controversial exercise, because without the relevant area beyond 200 nautical miles being verified by the CLCS, the reference to the submissions of the coastal states, as we saw from the example of Côte d'Ivoire, may turn out to be factually vulnerable, and the uncertainty involved in this exercise may render the disproportionality test inherently arbitrary. So to sum up, looking back at the two variations in the practice so far, I think the extension of an adjusted line to the continental shelf beyond 200 nautical miles tends to displace the application of the three-stage approach in the continental shelf delimitation beyond 200 nautical miles, because there was no construction of a provisional equidistance line, and the consideration of relevant circumstances was limited and partial. In contrast, a single exercise of the three-stage approach seems to be a better representation of applying the established methodology and better satisfies the pursuit of certainty, predictability, and transparency of the delimitation process. At last, based on the judicial and arbitral practices so far, we may see a trend towards the integration of maritime delimitation within and beyond 200 nautical miles under the three-stage approach, though there is still room for further refinement of the application of this methodology. I would also like to argue that the integration takes place not just in the formal sense, namely the choice of the same methodology as a matter of language, but more substantially in the examination of relevant circumstances, including recognizing the continuing relevance of coastal geography and the exclusion of the relevance of geomorphological or geological circumstances. However, as a final note, so far unclosed tribunals and the ICJ have dealt with the delimitation beyond 200 nautical miles only between adjacent coasts, and there was a practical need for the continuity of the boundary line. But the courts or tribunals have not delimited a boundary beyond 200 nautical miles for two opposite states, and there might be, and in the latter scenario, how the established methodology can be applied is subject to more complexities, because sometimes a provisional equidistance line may not properly divide the area of overlap. So would that be a situation where it is not feasible or not appropriate to draw a provisional equidistance line? Such a question has not been clarified in the jurisprudence yet. So it remains to be seen whether and how this three-stage approach can achieve an equitable solution in other and perhaps more complicated geographical contexts. And thank you very much for your attention. I will now give the floor back to Sir Michael.
Well, thank you very much indeed, Professor Liao. That was very clear and gave rise to some very interesting questions, which I hope we might have time for.